Rule 130, Section 24, Disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases. A. The husband or the wife, during or after the marriage, cannot be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. B. An attorney cannot, without the consent of his client, be examined as to any communication made by the client to him or his advice given thereon in the course of or with a view to professional employment. Nor can an attorney's secretary, stenographer, or clerk be examined without the consent of the client and his employer concerning any fact, the knowledge of which has been acquired in such capacity. C. A person authorized to practice medicine, surgery, or obstetrics cannot, in a civil case, without the consent of the patient, be examined as to any advice or treatment given by him or any information which he may have acquired in attending such patient in a professional capacity, which information was necessary to enable him to act in capacity and which would blacken the reputation of the patient. D. A minister or priest cannot, without the consent of the person making the confession, be examined as to any confession made to or any advice given by him in his professional character in the course of discipline enjoined by the church to which the minister or priest belongs. E. A public officer cannot be examined during his term of office or afterwards as to communications made to him in official confidence when the court finds that the public interest would suffer by the disclosure.